good evening, everyone, and what a turnout. Thank you so much for attending Oxford for Europe's third virtual meeting. Tonight, we're going to be hearing about our democracy and the rule of law, and we are absolutely delighted to welcome our two speakers tonight, Jessica Seymour, QC, and Peter Jukes. Each speaker will speak for about 15 minutes, and then we will open up the meeting for a Q&A session. Once again, thank you so much to our speakers for agreeing to speak tonight. I'm going to introduce each speaker in turn, and then Jessica Seymour is our first speaker. She's recognised as one of the country's leading public law experts, with particular expertise in EU human rights and environmental law. Jessica has acted in many cases which will be familiar to you all, including the first Miller case and the Good Law Project's challenge to the Electoral Commission and their decision to close their investigation into Vote Leave and Leave EU. Jessica is Vice Chair of the Bar European Group and the Bar Council EU Law Committee. More prosaic perhaps, but Jessica is also known to many of us as a respected and authoritative voice on Twitter, where her contributions and insights are hugely valued, and it is with great pleasure that we welcome her to speak to us tonight. I'll pass over to Jessica.
Thank you very much, Lizzie, and thank you both Lizzie and Peter for inviting me and organising this event this evening. I'm going to start with a quote from Dominic Cummings' blog of March 2019. I hope you'll forgive me not trying to put on his Mockney accent. But in this blog of March 2019, and you'll remember what was happening in those days, it seems so long ago, Theresa May was desperately trying to get her deal through Parliament, and at that time refusing to ask for an extension. And I think Jacob Rees-Mogg was pushing her to prorogue Parliament. Anyway, in that blog, he says, also, don't worry about the so-called permanent commitments of this historically abysmal cabinet are trying to make on our behalf. They are not permanent and a serious government. A permanent and serious government, one not cowed by officials and their bullshit legal advice, with which they have herded ministers like sheep, will dispense with these commitments and any domestic law enforcing them. So he put it pretty clearly that he didn't give a damn about the law and domestic law would be set aside. And I suppose this sums up what a Vote Leave government stands for, or put it its most kindly, what the Cummings and Elliott government stood for. A means justifies the ends approach, and one in which the law is nothing more than a hindrance, which must, if necessary, be broken. And that, in fact, goes right back to the referendum campaign itself, in which referendum spending rules were broken and Vote Leave and Leave.eu were fined the maximum fine possible by the Electoral Commission. What we have seen since these people entered Number 10 is a close to anarchical approach to our constitution, both to its non-legally enforceable but crucially important conventions and to its legally enforceable elements. And I can give you a quick list of examples, starting perhaps most obviously with the closing of Parliament, the prorogation of Parliament in the summer last year. Secondly, the refusal of the Prime Minister to release the Russia report produced by the Security Committee, and having been cleared by the security services, he simply didn't release it before the election, which was unprecedented. And recently, of course, the tabling of the Internal Market Bill on the explicit, I should emphasize explicit basis, that it breached international law, which of course is a direct breach of the Ministerial Code. To put it mildly, a minor perhaps compared with what it actually did, but also including within that bill massive lawmaking powers purporting to take ministers outside the remit of the courts altogether, and ignoring the Devolution Acts, which of course are constitutional acts. And then the Attorney General, in relation to that bill, seeking her legal advice from Vote Leave staffers, former Vote Leave staffers, a policy exchange individual who is also actually a professor at Oxford, the partner of Michael Gove's special advisor, who was also in Vote Leave, Henry Newman. His partner, another professor, gave advice, and then a former staffer from Vote Leave, who Cummings had explicitly praised on his blog as being instrumental in achieving the Leave result. So that, of course, raised the question as to why those individuals were asked to give that advice, how the Attorney General could even have heard of those individuals, because, of course, her role is to act independently and to go and seek independent legal advice on behalf of the United Kingdom to advise the Cabinet. And it seemed to me, at least, that the only way that she could know about those individuals would have been through Dominic Cummings and Michael Gove. And then the Lord Chancellor Robert Buckland's failure to comply with his duty under the Constitutional Reform Act in relation to the internal market bill. He has a duty to uphold the rule of law. Another example, appointing Leave loyalists as non-executive directors in government departments and indeed to many public posts. Further example, the pushing out of permanent secretaries, now I believe 5 or 6, from the FCO, the Home Office, the Cabinet Office, the Ministry for Justice and the Department for Education. And most recently, of course, the ignoring of the ministerial code in relation to the bullying findings against the Home Secretary, triggering yet another resignation. And amidst all this, we have the suspicions in relation to the fast tracking of particular contracts for individuals who have relationships with Tory ministers and MPs for many millions of pounds in relation to PPE contracts. So it is in that context that we have the Judicial Review Commission, which is supposed to be considering the balance between judicial review, the power of the courts, and the power of the government. And for me, the context makes that review particularly alarming. Another review has also been started in relation to the Human Rights Act and the so-called reforming of the Supreme Court. So these strategies all tend towards the same direction, strategies that to some extent play to the populist gallery, for example, the attacks on civil servants, judges and lawyers, but others which appear nothing less than an urge to power and a direct attack on the rule of law. In the context of the Internal Market Bill, we have seen the level of alarm that has spread into the most conservative elements of British society. This is not the Director of Liberty raising alarm bells. It is 2 former Lord Chief Justices, Lord Thomas and Lord Judge, former President of the Supreme Court, Lord Neuberger, Lord Sumption and others speaking out. These are people who are the very opposite of activist judges. They are deeply conservative with a small c, restrained and deferential to the executive and legislature. And the same indeed can be said for the head of the government legal department who's resigned and the Attorney General for Scotland who's also resigned. So the rule of law as we understand it today is under threat in this country, a threat that does, in my view, put our democracy at risk. As the German Federal Constitutional Court, Susanne Bayer, said, the rule of law frames, enables, and eventually protects democracy. And when the rule of law is undermined, democracy dies. So perhaps I should at least define what the rule of law is in short form. I hope there are not too many law professors listening to this. But put at its broadest, the rule of law is a principle of governance whereby all public powers are exercised within the constraints set out by law, in accordance with the values of democracy and fundamental rights, and under the control of independent and impartial courts. And the concept of legality with which public powers must comply includes judge-made law, Namely, the power must be exercised for the intended purpose, the law must be transparent and accessible, decisions must be reasonable, proportionate, and in line with any lawful promises or undertakings made by a public body. They must not be discriminatory, arbitrary, and they must be reached applying the principles of natural justice and in good faith. And the rule of law also requires institutional structures and delimitations of power. The state, insofar as it's conceived as being represented by the executive and legislature, must, as promulgator of law, also subordinate itself to law, which means the rule of the courts as adjudicators and enforcers. And it's in that interface that the struggle for power and legitimacy between the executive and legislature and the courts takes place. And in Britain, we are faced with a particularly acute difficulty in resolving that struggle because the core principle of our constitution is parliamentary sovereignty. That is the right of Parliament to make or unmake any law whatsoever, and the rule that no person or body is recognised as being able to override or set aside the legislation of Parliament. Now, Lord Judge, in his speech on the internal bill, appeared to accept this principle, and indeed all lawyers accept this principle, although there is dispute as to the point at which it will be broken. But in his speech, he made clear that if the Internal Market Bill was enacted, it would be our law and the courts would be obliged to apply it. And he compared, he talked about apartheid South Africa. He said that was a country in which apartheid was the law. No one could dispute that, but you could hardly say it was a country that had the rule of law, thus implying that Britain was heading in that direction. So in the UK, we do have the problem of maintaining the rule of law in a particularly acute way because of this core principle of parliamentary supremacy. And what really concerns me in this context is the contempt with which Parliament is held by those who occupy number 10. Having managed to replace many of the best Tories, people who would act independently when they had to, and you'll remember, I believe, 21 MPs having the whip removed. It was then organised that those standing for the last election were effectively yes men and yes women. And indeed, it is rumoured that several MPs were persuaded to stand aside in order to allow their safe seats to be given to such people in exchange for peerages. So what we have actually is a supine parliament which will enact the legislation that is put in front of it. I should say a supine House of Commons. And that was shown by the fact that the House of Commons waved through clauses 44 and 45 and 47. Those are the clauses as they were before the Lords. Actually, it was 42, 43 and 45. But they did go through the Commons relatively easily. And my fear is that this was a test for the Commons and that it may occur that another subsequent bill is enacted that grants powers in another context. I don't know how much you know about that bill, but those powers were powers that were given to ministers to enact legislation which effectively took them outside of the remit of the courts, but in the context of the movement of goods between Ireland and Great Britain and state aid. And having seen that Parliament will do its bidding, there is a real risk that this government will seek to enact such huge powers in another context. And that brings me back to the review that is being carried out into judicial review. The very existence of this review, in my mind, raises serious alarm bells, particularly when you see how it was introduced by its chair, who is a former Tory Justice Minister, Lord Fawkes, someone who's expressed strong criticisms, indeed said that both the Miller judgments were wrong. he said, together we will examine judicial review and the need to strike a balance between the right of citizens to challenge governments through the courts and the elected government's right to govern. Now, that makes no sense because there is, of course, no right to govern unlawfully. And judicial review is the most basic means by which the legality of executive action is determined. So just to conclude, it is a fundamental principle of our constitution that the courts decide the province, their province, their domain, and the courts are able to look at the legality of executive decision-making. And the fact that this government is putting that up to scrutiny, that core constitutional principle, for me is extremely concerning. To then read that there is going to be examination of the role of the Supreme Court is perhaps even worse. Just as with Brexit, there's a lot of noise about reform of the Supreme Court, but there is absolutely no detail or substance about what exactly is wrong with the current Supreme Court, and even more importantly, what is wanted from the Supreme Court. So just as with Brexit, I think we should be really concerned about what is being suggested, and there should be a real question as to what exactly are the objectives here. What is the purpose of all of this? That to me is the big question. So I'll leave you with that question.
Goodness, well, thank you ever so much. A sobering talk. I can almost feel the questions pinging in. What can we do? But I won't preempt them now. I will move on to our second speaker, who is a successful author, screenwriter, and investigative journalist. He describes himself as a dramatist wrenched out of fiction by the fierce urgency of fact and Rupert Murdoch. I think many of us here will empathise fully with that sentiment. Since the 90s, when he investigated Cash for Questions scandal, he has won awards for live tweeting the entire phone hacking trial and is now executive editor of the Byline Times, a newspaper intent on promoting independent evidence-based journalism, and which has been particularly prolific on the theme of unmasking illegal behaviour in high places. And it is with great pleasure and further ado that I welcome our next speaker, Peter Jukes. Thank you.
Thank you for having me. Lovely to see you all. I've never seen my screen filled with so many people. They don't usually do that in other Zoom things. And look, it's very hard to follow Jessica on the rule of law. That's a brilliant summation of where we are. Maybe I can look back a bit to certain forces why we got here, and some words of optimism. I think I first met Jessica probably a year, 2 years ago, obviously on the sort of second vote campaign. So I've been involved in this really since 2016, particularly the Trump election, oddly enough, as a journalist, and worked with Carol Cadwallader, the Cambridge Analytica staff, helped get the emails about Arron Banks, multiple visits to the embassy, which he said he only had one. The Russian embassy, that is. And the positive note, before I get into those dark stories, I mean, the law breaking, I think Jessica makes the point very clearly at the beginning, they broke electoral law. And that's not the only laws they broke. We know they broke data laws, and the Met, though they dropped it, were looking at conspiracy to break these laws. That was dropped, no further charges, these people are innocent. But I think that explains some of the story and what we're seeing now. And I've seen this as a dramatist who's been involved in long-running scandals like the Daniel Morgan murder. There's an iterative process. Wrongdoing happens, and the people get away with it, but there are people on their tail. And so they're always trying to mitigate the original wrong and to cover up and stop all the things that could get them caught. It's no mistake no coincidence rather, that Dominic Cummings often references when he's hiring some weird digital ad agency from New Zealand or some event, Cavalcade Cadwallader. Because part of the fight they feel is their wrongdoing or the allegations they're wrongdoing are catching up. And so we have this kind of strange process of cover up on cover up, attack, exposure, cover up. I think, so the good news about that, having watched the Trump campaign and being involved in that a bit, or anti the Trump campaign, is this is kind of a hiding to nothing in some ways, in that we've already seen the exit or apparent exit, but I think exit from the main strategy of number 10 of Dominic Cummings, who, as Jessica rightly outlined at the beginning, his ethos, his kind of quasi-libertarian, grumpy autocracy, data guru, quasi-genetics, it explains a lot of what's gone on, particularly during the COVID crisis. But he's no longer there. This is not, the Vote Leave team, they're very powerful and not full of trust. It's not it's an opportunistic, I would say, this is an optimistic reading of it. It is an opportunistic move, as we know from Boris Johnson, who wrote 2 columns, was it Leave or Remain? And apparently, according to Alexander Temerko, one of his biggest backers, Ukrainian-born, former Soviet citizen, said it was Eastern European businessmen who persuaded Johnson to go for leave. So underlying this is, I think, one of the things you have to look at, and where our language fails us at some point, is oligarchy. So we're talking about democracy. I cannot compete with Jessica on the rule of law on judicial review or say anything really much more about it. But one thing, particularly if you read the works of Timothy Snyder, Professor Timothy Snyder, who was a colleague of my mentor, Tony Judd, on the threats to democracy. And he makes this point, which Plato made 2,500 years ago. He said, democracy is not going to work. Plato said, why? Because rich people will buy it. And I think whether it's the PPE scandal, which Byline Times has led on, whether it's sort of some of these other procurements, whether you look at Russian oligarchs, the key word is oligarchs. If you look at hedge funds, like Robert Mercer, who funded Breitbart and Cambridge Analytica and has created this whole, apparently he's behind Parler, this new Twitter equivalent for right-wing people. You have an economic force meeting modern democracy, which I don't think we've quite seen before. And that is, and why Rupert Murdoch's important. When I first encountered it, when I found the phone hacking trial, my first 2 books about Murdoch, the third one's about the Daniel Morgan murder, which is connected. He said, I'm a free marketeer. I can't do Australian accent. I'm a free marketeer. I believe in meritocracy. Yet, he acts like a monopolist. He kills competitors. He games the regulator. He terrorizes politicians, and he tries to create a dynasty, as if anybody's seen Succession, could see the problem with that. He hates the royal family. He wants to be the royal family. Now, oligarchs have, we had this problem in the late 1930s, 20th century, trust busting. And we had the problem of railroads, Standard Oil, these big oligarchs coming in and basically fixing the market. I think since 2008, we've seen the same. Because if you were a smart hedge fund owner, businessman, financier, in 2008, when the cash machines weren't going to work, what happened? The state bailed out the market. And it was socialism for the rich. But if you were at all following market or just incentives, you go, why do I compete? Why do I sort of get an airline to try to compete with another airline and reduce the price of goods from China? Why don't I just get into government? Why don't I get into the Treasury? Why don't I get that massive subvention of money from the lender of the last resort? Murdoch had always slightly done that, by befriending prime ministers, kicking them out if he didn't like them. And I think the financial crisis creates, on the populist side, obviously, the kind of disaffection you see with the Tea Party, that Steve Bannon exploited. He wanted to start a Tea Party in England, Britain, with Nigel Farage. A little bit difficult because the Tea Party was about kicking out the Brits. So he sort of worked on other things, including Breitbart and Cambridge Analytica. But there's this populist dissent with the failures of financial capitalism. And then I think rich people thought, very rich people, thought, well, why bother competing? Why not just own the government? And of course, the precursor to that model was the former Soviet Union. When that collapsed, the privatization was so chaotic, led by us, led by Britain and the IMF and places like that, that the only way to survive was mainly mafia and KGB take over the state assets. So I think when we're facing this on an economic level, people talk about neoliberalism and privatization, Reagan Thatcher and deregulation. There's a fight within the elites. This is not, Richard Branson is not on the side of Arron Banks. And there's two models, if you like, I don't even call it capitalism. People call it crony capitalism. I saw a question already about chumocracy. Somebody else is using the word plutocracy. As I said, we've covered a lot of this crony capitalism. In the last year, there's emerged from the contracts of government, under the inspiration of Dominic Cummings, who believes procurement is corrupt and then does this and has a 100 billion space project. So I think these are fundamentally economic forces driving us, and they're international forces. A lot of American money, and we have tracked this on Byline Times, the dark, not just Mercer, Horowitz Foundation, a lot of right-wing libertarian US networks funnel their money to dark think tanks in London, which have a big purchase on the Tory government, have a big purchase in the media. And they saw, as Andy Wigmore said to Carol Cadwalder in 2017, before it all became contentious, that Brexit was a petri dish for Trump. And in that money, and this is not an anti-Russian thing, by the way, in those offshore funds, those archipelagos of dark money, which trillions are in the system now, offshore. That's where the money of Robert Mercer mixes with Oleg Deripaska. And we've seen this transnational war between the elites, between an old set of elites who kind of work, maybe modified, deregulated the rule of law, but kind of like to keep respectable, and another, they call them disaster capitalists. I think oligarchs is better. Are they capitalists? They don't really compete. They don't believe, they sort of amass and own governments. A kind of desire, the destruction of the rule of law benefits them in the offshore havens. They can maybe make money on the side. And looking at the way, the rule of law is determined by material values, by people's ownership, by their interests, and by media pressure. A lot of these people, like Murdoch starts with, own big media companies, have a lot of social media operations. That is driving a lot of that. So the two bits of good news are, maybe not so good for the UK. The first bit is, I think, the victory of Joe Biden, the defeat of Donald Trump, which has finally been ratified by Michigan and Georgia, I think, and it's going to happen, is a big defeat for those forces, because they banked on a kind of global system of this happening. Now investigations will continue. Some district in New York, obviously Bannon's been arrested for fraud, indicted. There are serious investigations which will expose the wrongdoing around Trump, and I think percolate back to UK figures, Brexiteers, or certainly dry up some of that money pouring in, millions pouring in through London, Tufton Street, Henry Jackson Society, all these foundations which were kind of pushing this populist agenda. And, their new war, by the way they distracted from, the rich getting more money was to pick on immigrants and particularly Muslims. So they had quite a complicated construct how this would work. The war against Islam and roaming, Roger Scruton called them roaming tribes of Muslims, immigrants. Meanwhile, we raid the state. That will come to a halt, thanks globally, I think, to Biden. I think there's enough impetus there. It will stop, put in check all these populist movements with so many abuses of human rights. We've seen from Myanmar to Xi'an and what's happened to the Uyghurs, happening in India now, what's happening in Kashmir. Some of that will come to an end. But it leaves us as a rump Trumpocracy because, one of the reasons Cummings really left, I think, was the Biden one. And they were banking on this global, they were banking in 2016, by the way, on the EU collapsing when we left. If anything, if Britain's exemplar of anything is don't leave the EU, rather don't withdraw from international institutions because you are left alone and exposed. And Biden will underline that. He doesn't like Johnson because of his racist comments about Barack Obama. His new Secretary of State has said Brexit is basically the same as Marine Le Pen. And of course, they're very protective of the Good Friday Agreement. So that's the good news internationally. Nationally, it's not so good news because that leaves us a rump Trumpocracy. Even the dark money of the dark money of lobby think tanks won't be so interested in us. We're no longer so influential. We're no longer a petri dish with an example of what not to do. And so some of that money will drain away from those right-wing think tanks. But of course, as things get worse, we have the possibility of even more nativism, even more blaming and othering of people. And I think it's on a knife edge. I do think it really helps the cause of a non-hard Brexit. I'm not surprised you're hearing voices in the press from the Bank of England to Nissan saying no. So in that way, for us, for anybody who believes, if you like, in rule-based behavior, it will push us closer to the EU, though we will not have the power on it. But my final thought for questions is really from what Jessica says. She's outlined all these amazing, beautiful mechanisms and rules by which, power is not co-opted by the powerful against the citizen. But the British system is really weak. When everybody says it's terrible what happened in 2016 and onwards, I agree. But every weakness that was there for them to exploit was there before they exploited it. Whether it's the dominance of Murdoch, the kind of lack of arm's length distance of the BBC and Bravery, whether it's, that so many of our norms, so many of our rules of behavior, and there's still code, is a norm. There's no, they presuppose decent people who went to Eton. What about indecent people who went to Eton, let alone Dominic Cummings? And so part of my feeling of hope for the future is finally we have to confront what was wrong with this country, its weaknesses. America did this. America, when founding fathers wrote its constitution, they say, what if a bad person got in power? What checks and balances? We can see the weaknesses in that. Look at the problems of the transition. But at least they thought that through. Have we ever really thought through? Except for decapitating a king and then reinstating his son and then having the Reform Act and all the things we did, glorious revolution. What if bad people get in power? Because I think we have bad people in power and we have no protections. And this is a wake-up call.
Well, thank you very much for that. Both very sobering talks. And I think, yes, I think we all felt that relief when Biden finally was, confirmed the elected president, and it gives us some cause that to hope for progressive politics, but it feels a long way away. But I'm now going to pass to my colleagues in Oxford for Europe to ask, I'm sure we've got a whole raft of questions to ask of you both. Thank you.
Well, thank you. Can you hear me? So first of all, thank you very much, both of you, for very thought-provoking talks. As you can imagine, the chat is filling up with questions. The first one actually comes from Sarah Murphy, and it builds slightly on what Jessica said at the beginning about judicial review. When a government is prepared to break the ministerial code and wants to limit judicial review and possibly scrap the Human Rights Act, the judiciary becomes the last line of defense in the protection of our constitution and democracy. Weakened by attacks in the press and by government ministers, is it strong enough to withstand?
I have very great faith in our judiciary, and particularly because recently, in the last 6 months to a year, a whole raft of fantastically independent, brilliant public lawyers have been appointed to the High Court bench. And I must say, I don't think it's necessarily a coincidence, in the sense that I do have a suspicion, based on absolutely nothing, I should say, but I do have a suspicion that there was an awareness that the bench needed to strengthen its constitutional lawyers, and went around and possibly tapped on the shoulders and asked a number of brilliant people to apply who did. Now, that is literally, I have no basis for that suspicion. But the bottom line is that the High Court bench now has at least 6 new judges who are very strong, independent individuals, and each one of which, certainly worthy of the Supreme Court, will likely all eventually arrive there. So, I think our judges are very independent. That said, the law has its limits. And whatever you do, I mean, I acted for Sue Wilson in a case where she was saying that the decision of Theresa May simply to ignore the illegality of the referendum, so the unlawful acts that had been discovered, the referendum offences, the other offences that Peter mentioned, the Russian suspicions of Russian interference, etc., simply to ignore it, not even to raise the question and consider the question, was unreasonable. Now, the court wouldn't even hear that case. I actually happen to think that there was enough to say that that case was arguable and could be heard. But it is true to say that the referendum created a certain hysteria and a certain effect, which did have some kind of reverberations of fear within the courts, I believe and I feel. But I think we're way past that point, way past that point. And I think that we can rely on the judges to be independent, but what we cannot rely on the judges to do is change the law, because that's not their job. That said, in a case called Jackson, Lord Steyne, now deceased, made it very clear that there may come a point in the future where parliamentary supremacy will have to be rewritten. He made the point that parliamentary supremacy is a creature of the common law and therefore can be undone by the common law. But it would take some strong judges to actually take that final step, because that would be a huge constitutional crisis in our country.
Thank you. Peter, would you like to add anything to that?
I don't think I can add on that, except to say, yes, my experience of lawyers, that in a way, and judges and the bench, is that we are, in that way, we're better than America. They're not politically appointed. I remember sitting through the phone hacking trial. Lord, I got to know him so well. He'd call me up. My Lord, there's been a tweet. His name's escaped me, but I came to love the judge. It'll come back to me. But I will say, why Rebekah Brooks, why the phone hacking trial went a certain way. And if you read my book on it, or Nick Davis's book on it, was money. There is a sense, I mean, at least that was a criminal trial, but still, they spent £70 million on it, and the state spent £1 million on it. And I don't know if this affects what Jessica thinks, but obviously, the courts have been drained of money. That's one of the signs that it's really, since Cameron, how much they value the rule of law. They're constantly draining the court process of funds and efficiency. My fear is, that they wouldn't, but then we have the prorogation judgment, the Supreme Court judgment there, which was startling, that, that there was something that could overturn Parliament, obviously on its own basis. It was overturned on the basis this was overturning Parliament. So it'd be fascinating to see, and all I'd say is, I really hope Jessica's right, and that may be the process, maybe always the British process, whereby we reform or find our constitution or articulate its underlying premises, even if it's not written down. Somebody's asked a question about written constitution, well, there are problems with the written constitution. You can't write everything, you're constantly amending it. And in fact, there is an unwritten constitution, which I suppose, Jessica knows more than me, is found in the precedent of our laws.
I think that's right. I can just add to that those common law principles, that executive decisions should be made for the purpose they were intended for, should be transparent, that law should be public, all those kind of things, which theoretically, under those clauses in the Internal Market Bill, if they are returned and enacted, are set aside. Those principles derive from the common law, they derive from administrative public law, and it is possible that the courts would say that those principles are so fundamental that Parliament simply cannot legislate, even absolutely clearly, explicitly, cannot legislate to get rid of them.
Which would prevent the kind of, without breaking any Godwin's law, of the Enabling Act in the 1930s, wasn't it? Which allowed, just one heartening bit of news, I don't know if you've seen, maybe you will have, Jeremy Moore just tweeted out that his judicial review, I think mainly of the, wasn't one of the procurement cases and certain contracts given to Cummings, his friends, is arguable. So they seem to have gone through the first hurdle of the judicial review. So there's good signs there. Have I understood that right, Jessica? Have I understood what?
Right. Given permission, which may even have happened on the papers, then right. At least there will be now some disclosure of documents.
And were you surprised by that?
Well, I haven't looked at the detail of the case, but I mean, so I don't know the legal basis on which they're doing it. So I can't really say, but I mean, I would have thought it's an appealing story, and actually in judicial review the story is quite important.
Thank you. The next question that we have, I think I'll direct to, can you hear me? Yes. I'll direct to Peter first, because it's slightly different. And it's, when will any political party want to represent the majority of liberal pro-Europeans, or did the Brexit referendum loss mean no political representation for Remainers? It actually says ever again, but I'll just say in the near future or even a long time ahead. Peter.
Oh, this is the area of political speculation where I always get a bit lost, partly because, I'm trained now. Wildline Times is non-partisan, we're independent, we have readers. Peter Oborne writes for us, One Nation Conservatives, the Green, to Corbynites, to centrist Labour's, Liberal Democrat, big supporters there. I think, this goes back to much more profound things, that the Remain voice got categorized as Remoaners, as middle class intelligentsia, part of the whole populist backlash. Obviously, we're no longer talking about Remain, we maybe talk about Rejoin. And I remember, it wasn't it? This time last year, the election. I mean, there was and I know you look at Aaron Banks's messages, not however I read them, I don't know, they just happened on the internet. They were really worried, the key Brexiteers, they were losing it in 2018. Partly, I think, obviously mass protests, those mass gatherings in London and other cities, the revelations, particularly from Cal Cadwallader, about vote leave illegality, about the influence of social media operations, Russian influence, you name it. They were very, very worried. And I had this feeling, again, this is me, my background as a dramatist, I'm only recently a journalist the last 10 years or so. It was like there was this huge battle for 2 years. And then suddenly, last December, we were defeated. I mean, you cannot deny that whatever means they used, and the failure of Labour to make a decision, and the bifurcation of Labour and all the class issues, and Jeremy Corbyn basically instinctively a Lexiteer, they won. And the plane was covered with victorious enemy. And I remember actually saying to Cal, I felt I've retreated to the hills, and there they've got the planes. They go, yeah, Remoaners, we beat you. Yeah, and I'm stunned. I'm just thinking, well, what do I do? And I sit on this mountain, and then suddenly in the distance, all cheering, there's this dark, dark mist coming. It's COVID-19. That's happened to Trump. I think populism, this finding enemies, that's what they did. Cummings produced this lie about Turkey sending millions of Muslims to the UK. They fought on lies and fear. They fight each other on lies and fear. But that is not based on reality. It's not based on economic reality, our diplomatic reality, our social reality. They go so far, and then reality hits them. And the reality of a global pandemic, and we were the first to cover like the whole herd immunity thing, which I'm pretty sure Dominic Cummings came, well, Sunday Times reported he did come up with it, then changed his mind. The ideology of hatred, the ideology of power, the ideology of divide and rule, it's very imperial ideology. I think there's a lot of private schooly, educated people with imperial backgrounds in their families. I can name key Brexiteers, whether it's Belize, Zimbabwe, wherever you like, have an imperial background, wanted to divide and rule, and they're very effective at that. They've been doing that for 300 years. But that doesn't change reality in the end. And when you create a scientific problem like COVID-19, when you're confronted with international cooperation, the PPE thing arose, we've done 20 stories on that, because the British refused to go in with the EU procurement deal. So they're running around the world, getting to China, just ridiculous sums of money for a lot of the kit didn't work, because they ideologically opposed to anything with the EU. That is unsustainable. So as I sit on these mountains, I do know that their project will not work. The problem is the collateral damage to us.
Thank you, Peter. Jessica, is there anything you'd like to add?
I agree with Peter. This is not going to work. None of this is going to work in the end. And it seems a long time away, but actually an election could come sooner than 2024. I mean, this government has never had any central heart to it. It doesn't have, at least I can't ascertain any purpose for which it exists. I listened to what Peter said in his talk, and I'm sure that money is being siphoned off left, right, and centre by whoever. I mean, no doubt that probably all that likely is happening. But I find it very difficult to believe that there's a central organised conspiracy. It seems to me that the whole thing is quite random, and as such could equally collapse. And depending on how bad Brexit is, it may collapse sooner rather than later, because the combination of COVID and Brexit may actually lead to riots. It's a sad way to put it, but it may be that the government will collapse through a process similar to the poll tax riots we had years back. But in any event, 2024 is not so far away. And I would have thought if Labour can hold together, we would probably get a new government. We would probably get a Labour government. Maybe we'll get a reconstituted Conservative government. So as for whether anybody is going to represent Rejoin, again, I think that's dependent on what happens. And I think that it will depend a lot also on the cry from people, younger people, wanting the opportunities of Europe. And when people start realizing quite what they've lost, I think that may impact on the way that parties behave.
Can I add just a further thought to that? When Anthony Barnett makes a very good point, I think that's him, the writer, and he, Britain hated the EU as a superstate back to Thatcher ousted in 1990 for that reason, because it actually is a superstate. There's a great line by, I think it's Timothy Snyder, says, name to me a nation state 100 years ago. There are none. I think Finland might have been one of them. Everybody else, every other nation state in Europe was either part of somebody else's empire or the center of an empire. And so the EU was the way of getting over empire for most of the imperial British states, the sub-dominions, whether it's Croatia or Hungary, or the Austro-Hungarian Empire, whatever. And we never went through that process because we never suffered proper defeated war. And my feeling is, and this is why Brexit always gets escalated, because, as we all know, there's 17.2 million different versions of leave. And it always, like Gresham's law with cars, it always goes to the most extreme one. And so what I think what the Rejoin movement will not be the Britain we know. I'm not saying Britain will break up. I may need to come federated in a different way. But you can see a different, and I don't think Europe would have Britain back as it is, this sort of rogue, semi-imperial super state that thinks it's in the middle of the channel, has never really liked Europe. And this is where the Remain movement is really important, things like March for Change. We are Europeans. We do believe in these principles about the rule of law and rules-based. And we can act as though we did. We can, even if we've left, we can make sure there's more convergence. And eventually we will have joined in our hearts. Because, you know, before the EU, we were there with the human condition and human rights. So you know, act as if we are there, and whatever that weird edifice of Britain, we might come back under a different guise, because Brexit could mean Britain leaving the world, but we as Britons, as Scots, as Welsh, Northern Irish, could still rejoin Europe in a different form.
Thank you both for those very full answers to that last question. We're now going to ask Colin Gordon, one of the members of Oxford for Europe, if he would like to put his question. The question is, do the panelists have any comments on the activities of the Oxford Uni-based Judicial Power Project, led by Richard Eakins, which is backed by the Policy Exchange think tank, and which seems to be acting as an incubator for the government plans to curb judicial review? Jessica, do you have a view?
Yes, I do have a view. I've been watching this project for many years. It started in 2015. And Richard Eakins then was a young chap who went on panels, and I went on a panel with him just after the Miller judgment, in fact. And he was one of those young chaps who sort of, you thought, well, he's taking this line because he'll get onto CNN quite often, you know, or Question Time or whatever. Because if you take this extreme position, that really, as a lawyer, was just completely untenable. The articles he was putting out and the points he was making, completely untenable. You're doing it because it's a quick, you know, way to get exposure. But anyway, he's gone on to actually obtain somehow a professorship, which strikes me as a lawyer as absolutely extraordinary. On the Judicial Power Project website, you find a review of the 50 most important administrative law decisions. And underneath each one, you get a little paragraph by Richard Eakins slagging off some of the greatest judges in our history, setting out some of the most important constitutional principles and explaining to the world why all these great judges were wrong, which again, as a lawyer, is frankly, one just finds absurd. So the Judicial Power Project is a project that has pulled in all kinds of Brexiters and libertarians, some highly eminent. For example, a historian called Noel Malcolm, who's a historian in Cambridge, but also a world expert on Hobbes, was recruited to write a pamphlet for them about the Convention on Human Rights. And he went through all the case law and wrote a pamphlet that conveniently concluded that the United Kingdom should leave Strasbourg. And he did a legal analysis which didn't stack up at all as a lawyer, legally, made no sense. But there is this production by this project by extremely eminent people who have particular views about the world, anti-liberal views, tending towards hyper-conservative, sometimes Catholic, Orthodox kind of views. And the objective of this project, I think, is ultimately to move to a United States system where you will have judges appointed by the executive. I think that's their end point. And again, it's the looking over the pond at America and trying to imitate what they have there. And one huge problem I have with the policy exchange is that it is absolutely impossible to find out who funds them. It's equally impossible to find out whether Richard Eakins is paid and how much, whether Noel Malcolm is paid and how much, what they were asked to do, etc. So the whole thing is opaque. And at an academic level, that is very disconcerting, because the one thing you expect of academics, lawyers and professionals is to be completely transparent about who is funding them and what they were asked to do and why. And you'd expect that to be on the first page of any pamphlet, and none of that is there.
Thank you very much for that comment. Peter, do you have anything you want to add?
I'm not in detail of that organisation. Jessica knows much more than I do. I mean, but I would just say that hearing the description of it and the way policy exchange were involved, this is the dark money that's come from US, not always US, funding policy exchange is one of those Tufton Street associated think tanks, which refuses to declare its donors. But in America, you can find some transparency because there's different disclosure rules. And there have been millions poured into the UK, partly by the religious right, sort of this weird libertarian right-wing group, which are always quite authoritarian when it comes to the death penalty and things like that. But one thing I'd add to that, and the interesting thing is the role of the media in that. So I couldn't help noticing, there's always kind of little people who pop up and give you alert what's coming. As soon as the Supreme Court judgment came in about prorogation of Parliament, Tim Shipman piped up, oh, we're going to have to appoint Supreme Court judges now. So this thinking, there is a coterie, and they literally employ each other in a revolving door between think tanks and media. Yeah. They often are invited on the BBC. They don't declare their funding. Our particular recent example of this great Barrington Declaration. I don't know if you remember, a few very tiny number of so distant epidemiologists, but they weren't actually particularly qualified in that field. I think Sunetra Gupta was involved, and maybe Hennigan, had this great Barrington Declaration that, we should move towards herd immunity and just protect the vulnerable and things like that. And our journalist Nafeez Ahmed discovered this is the same network which was climate change denial. The AEIE, the PR company involved, does a lot of the climate change denial stuff. And so you see this pattern. And my hope is, as Jessica says, we don't allow opaquely funded bodies. Academia shouldn't allow it, but that's one of the points of entry. And it will dry up as we become less of a kind of avatar or symbol of what's great about the Anglo-Saxon world. Anyway, that's all my own observations on that.
Thank you very much.
Well, thank you. I just have another question here. This is a question from Barbara Clark. And unfortunately, I think I know the answer to this question, but it's tempting nonetheless, having seen the play King Charles III. Should the Queen sign into law an act that breaks international law? If not, is there a way she can refuse?
Well, I think, Peter, you're going to have to answer it, because I don't know the answer to that question.
I think we're just going to have to make it up, aren't we? I don't know the answer to that question. Does anybody out there know the answer? Hands up, who knows the answer?
Well, Peter Burke thought he might know the answer.
And what did he say?
I mean, the question arises, I suppose, from, we are a constitutional monarchy, aren't we? I mean, that is meant to be, at the end of the day, the Queen is the final person who puts the signature on anything before it comes to law. But at the same time, Parliament is meant to be supreme. And in this case, the two could come into conflict. What would be the outcome of such a conflict, I wonder? I mean, it's hypothetical. I would guess that she would never do it, but it's a tempting question nonetheless.
I mean, I would assume she will do what she's told, and she'll sign whatever she's told to sign. But, equally, I can see that if a minister comes to her and says, well, this is going to put the UK in breach of international law, will you sign, ma'am? she might say no, but I doubt it very much. I don't know what the correct legal answer is. But...
Phil Jones has an answer, apparently. I've sent several messages from Phil Jones.
Well, the British Library has a really good article on the British Constitution. It's called Our Unwritten Constitution. And it says that the Queen has legally unchallengeable power to refuse assent to any bill passed by both houses of Commons, both houses, the Lords and the Commons. But practice dictates the opposite. In practice, the Queen automatically gives her assent to any bill passed by both houses. And that's what it says on Our Unwritten Constitution on the British Library website, bl.org.
Okay.
So if she applies Cummings rules, she can refuse to sign it.
Yes, exactly. If we're breaking precedent, why doesn't she?
Well, indeed. And of course, the House of Lords hasn't actually approved the internal market bill. It may be forced to assent, but it has never actually said that it agrees with those provisions.
Ah.
It's taken them out. I think it's taken all of them out. So we'll go back to the Commons without any of those provisions.
So thank you very much indeed. Over to you, Susan.
So we have a question from Mike Cashman, and it goes back to the prorogation that failed partly because of the resulting inadequate time for the Brexit legislations to be scrutinised. Any timetable now for a deal would also allow inadequate time for parliamentary scrutiny. So can that timetable be challenged in a similar way?
Well, it wasn't quite like that, because what was challenged was the decision to prorogue Parliament, and specifically the advice to the Queen that she should prorogue. And the reason the challenge was successful was because the Prime Minister didn't tender any evidence to explain what the objective reason for the decision was. And I think I said earlier in my talk that if you're going to exercise an executive power, you've got to do it for a proper reason. Now, if the Prime Minister had come up with some reason, it would have been quite difficult for the court to say that that wasn't a proper reason. In fact, in the Scottish case, the judges actually made the finding of fact that the reason he had prorogued was to stop debate in Parliament about Brexit. But the Supreme Court was much cannier than that. It didn't actually, it just said, well, you haven't put a witness statement in front of us. We've got no witness statement with you explaining why you did this. So since you haven't got a reason for doing this, obviously it can't be lawful. So in fact, the Prime Minister was not very clever, because he should have given any old reason, and then it would have been much harder for the courts to say that that was not a legitimate reason. Now, it's rather different with no deal. I mean, the Parliament has already allowed the Prime Minister to take us out of the EU without a deal. So nothing unlawful is happening. If we leave with no deal, there's no illegal act by the executive.
Thank you, Jessica. Anything to add, Peter?
No.
No. I'll hand over to Jo now. Thank you.
This is a question from Ruby Ziegler. I think I'll probably address it to Jessica first of all. Do you think there are prospects for judicial reviewing of the internal market bill on Jackson grounds? As in Lord Bingham, the supremacy of Parliament is still the general principle of our constitution, is the construct of the common law. The judges create this principle. If that is so, is it not unthinkable that circumstances could arise where the courts may have to qualify a principle established on a different hypothesis of constitutionalism?
Yes, I think it is possible. I think that there are some problems in relation to it. I mean, there are lots of problems in relation to it. The first problem is you've actually got to have something to judicially review. I don't think that you could turn up. Let's assume that the government put back those clauses and they go through the Commons, they go through ping pong, and eventually they get this act through using the Parliament Acts or whatever, and becomes law. You then have a law giving ministers power to enact legislation by way of secondary legislation, so without proper parliamentary scrutiny, which gives them the power to do whatever they like in breach of any law, domestic, international, common law, whatever, and for that not to be unlawful. So it renders all unlawful acts lawful. Effectively, what the executive has done there is made itself parliament. It's taken parliamentary supremacy onto itself. So then what do you challenge? You can't turn up at court with the clauses and say that the clauses are unlawful, or perhaps you can. So the first question would be, can we just go to court with these powers and seek a declaration that these powers, as they are unlawful? I think that would probably fail. So you'd have to wait for the ministers to enact secondary legislation, and then you'd probably have to wait for them actually to use the powers. And then you'd have a challenge to the use of those powers. So it all gets terribly complicated, and you may end up with some narrow bit that is challengeable under some common law principle, but you don't know what it's going to be. And added to that, I would say before you get to the point that you have a court case, you're likely to have a lot of things are likely to have happened. So if you take, for example, the power to give state aid under these secondary powers, if the secondary powers provided that provisions of state aid should be completely secret, so, or not subject to Freedom of Information Act, not published, then how do you actually find out when the government has given out a contract? If there's secret guidance, so the guidance in relation to the provision of state aid doesn't need to be public. Under common law, guidance needs to be public, but say these powers say it doesn't. Then the guidance says, provided you have give a X%, so a kickback effectively, you give 10% of the aid that we're going to give your company back to the Tory party, you can obtain the aid. And that's in secret guidance. Now, I'm raising the most kind of sinister hypotheticals. I'm not saying that that's going to happen, but we do know from what is happening in Hungary and has been happening over the last 5 years that these are actually standard approaches to the giving out of government money or licenses, tobacco licenses for shops, that kind of thing, or planning permissions. So these are actually standard things that do happen quite frequently. So my concern is, yes, you could one day get to court with such a challenge, and you might persuade a court to say that secret guidance is a breach of the common law, and it doesn't matter what Parliament says about it. You can't give yourself a power to do things according to secret guidance. That is likely to be a very long way down the road in terms of timing, and a lot of harm is likely to have been done by the time such a challenge got on foot.
Okay, thank you. It seems very horrifying that we're in a position talking about these issues at the moment. It's just slightly crazy, really.
Well, it is possible, of course, that these clauses will never actually be enacted. The question is whether they'll try it again with something else. You know, I don't know. I don't know what it was all about. It struck me as an extraordinary thing to do.
Practice run for worse things. Peter, do you have a comment to take on that?
No, I have a question. I mean, I'm learning all the time. Thanks, Jessica. My question would be, I mean, they're obliged, Byline Times would be delving into them to publish the majority of the PPE contracts. And we have the testing contracts coming up soon. But that was under EU law, wasn't it? I mean, does this all fall away, this obligation for transparency over government tenders, or actually non-tenders, non-compete, when we leave in January?
I think it depends what Parliament decides. Whether most EU regulations have been brought into UK law through the first Withdrawal Act 2019 or 2018 Act. They came in through a secondary process. So most of that stuff is now in our domestic law, but there's no, there would have to be separate UK law requiring transparency of contracts. And I'm involved acting for Friends of the Earth, challenging a UK export finance funding of 1.15 billion funding that is being given to Total for a liquid natural gas plant in Mozambique. Now, we couldn't get any of that information. And it's only a question of practice that they publish anything on the website. And it was only through the court that we actually got, by luck, that we actually got that. And we've certainly not had the contracts. So, I mean, we may get the contracts after further legal disputes. But I can't see any reason why, as a matter of common law, there should be any obligation. And it's certainly, if there was, it's something that Parliament could certainly override.
Okay, thank you both. I'll hand you over to Peter Burke now for the next question.
Well, thank you. I mean, Peter's been very active in bringing to light a lot of the misbehavior in public life and the way in which both politicians and people in business have been abusing the pandemic in particular. But do you think there's any way of achieving legal redress? Rosemary Morland asks, is there any way to penalise these oligarchs and make them pay through significantly higher taxation for support for businesses, PPE, etc., during the COVID crisis? And if so, how do we do it? I think I'd broaden that and say, is there any way of bringing them to justice?
Well, I have to defer on the legal aspect of it to Jessica. I do know from the legal letters we get that they find this embarrassing, but I suppose when you get to about 140 million, the embarrassment moves away. And always my fear, going back to the phone hacking trial, and the chief executive of that news, the editor, not knowing that most of the staff were phone hacking, going back to the same job, having shown, if not criminal guilt, she was found innocent, complete negligence and incompetence. That I always thought in 2013, if I was sitting through that trial, a bit like the Leveson hearings, most of us going, that's awful. A lot of people thinking, how can I do that but better? They'll see it as an instruction manual. And I say Cambridge Analytica formed around that time must go, we could do it much better than phones now. We could hack people's Facebook accounts. Though I don't think they're quite articulated that way. So my fear is that in the meantime, as Jessica says, the harm that's done, how many other companies now going, I'm just going to donate money to the Conservative Party? We tracked over £500 million worth of PPE contracts going without tender to Conservative Party donors. And Julian has a lot more. So I don't think Jessica says she hasn't read the, why it's arguable as judicial review or that they're taking the case forward. But Julian certainly thinks there is a case under common law, doesn't he, Jessica?
Yeah, I mean, I have to say I haven't engaged with the legal questions here. I mean, there's EU public procurement law, and that could have been set aside for because of the emergency. But I'm completely perplexed about a lot of these contracts, particularly the ones that where goods have either not been delivered or have been faulty? Because it seems to me that any basic contract protects the purchaser in that context. I mean, even in basic consumer protection law, if the goods are not fit for purpose, you get your money back. So at a high level commercial contract, I simply cannot understand how that money is not returned or never paid by government. So I mean, there will be real questions about that, but I feel very concerned that, you have the audit committee looking at all these things and writing reports saying how bad it is. But actually what you want is the money returned to the Treasury and any wrongdoing prosecuted.
There's a report out, the second half of the report, I've got to publish it after we finish this, at 3 minutes past midnight, is out tonight, and it's even more damning, yeah.
Yeah, I mean, whether there's been any criminal conduct, any bribery, any of that, I mean, one just cannot know, but someone needs to investigate it, obviously.
Well, we know there's cronyism involved, and there was a fast track, which you had like 10, 20 times more likely of getting a contract if you were contacted for a VIP route. A civil servant, an MP, or a member of the House of Lords.
But what I don't know is whether that is unlawful if you're outside of the procurement process. I mean, obviously, if you have to be within the procurement process, but if you're outside of it and their defense on this is, look, we had to act quickly, people turned up who we knew, we trusted, we gave them the contracts. It seems pretty weak to me, but I can't make any assessment, sorry.
Interesting. One of the comments on the chat was that we talked about cronyism, but I mean, kleptocracy seems to be almost an appropriate word in these circumstances. We have a question from John Hill.
Yes, and I will ask that. How much of a help is the work of the Good Law Project? Will their cases get a good hearing? Peter, would you like to take that first?
Again, because I don't, and both Jessica and I are pleading slightly in ignorance of the law involved and the chances, though it has been admitted, or it's admitted it's arguable, whatever the legal term is. He just tweeted out 2 hours ago. There's good news on that. What is redress here? It seems to be. I can't really talk about the legal side. I can talk about the media side, because we've been plugging away at this with others since June, I think. Jolyon must have started in May, Open Democracy did a bit. We just dug and have all those stories. It only became a matter of public knowledge and covered by the major media networks, ITV, Channel 4, and the newspapers. The Mail did not a bad piece on it, actually, and the Mirror, when the NA report really hit the web, because otherwise they're going crazy conspiracy theorists. There's far too much work. It's much easier to take an NA report, use that as your legal basis. And so all I'd say about that, Jolyon's very good at public interest law, and it always needs the support of journalism, I think. And one of the great problems, as I said, the weaknesses Brexit has revealed is our media ecosystem. I mean, I'm not that wealthy at all, but I've had a career in another life. I paid off my flat. I can afford to be in journalism. Most young people can't. It pays very badly. The money's been sucked out of advertising by Facebook and Google. Billions have left it, leaving journalism the domain of children of publicly school educated or connected kids who basically want to get in the world of political power and the lobby. They move in the world of opinion. We are run by two punditocrats, Michael Gove and Boris Johnson, whose understanding of journalism is basically how to win an argument on the flimsiest of cases, and to network with power. So I think even if Jolyon plugs on, it needs media scrutiny, it needs the embarrassment of the crowd, it needs the shame and the public activism. And the law, while brilliant, is formed in a social milieu. And the outrage, the attended prorogation, that was a classic moment because there were many people animated by this very extreme maneuver, which Crispin Odey, by the way, seemed to know about before Johnson even won the leadership, that was market moving, which was constitutionally extraordinary and seemed to be propelling us off a no-deal cliff. If, in the end, you know, it needs the public to be animated by these things.
Thank you. Jessica, do you have a comment on that?
I can't add on the law. I can simply say that there are also other mechanisms, the National Audit Office, the Public Accounts Committee, and ultimately Parliament, and crucially, as Peter says, the media. And these, you know, they may not get the money back, they may not get people in jail, but they are very important systems as well.
Okay, thank you very much. And I'll hand back to Peter Burke, what I think might be the last question.
Well, time has flown, hasn't it? And this is a question actually, again, from Sarah Murphy, and about the opposition or lack of it in the context of Brexit. So Labour is likely to vote for the miserable Tory deal and has essentially missed its chance to let people know what it actually means for their lives. The country enters 2021 woefully ignorant about what lies ahead. How do we connect the dots and not allow COVID or the EU to be blamed for the inevitable damage?
Well, that's why I spent my life trying to do this. Also, the original wrongdoing. You know, this all stems, as I said, from the original illegality, the cheating and the lying, which were not criminal or unlawful in the campaign we saw, but unlawful activity in their spending, unlawful activity, I believe, in their data operations, and what hasn't been investigated, collusion, but with foreign, or you know, participation of foreign influence. You can't have a democracy where people spending money in your democracy to affect a result of which they're not going to be, you know, anything but a beneficiary of. They're not going to pay taxes there. They're not actually going to live with the consequences of that. I think America's beginning to do that. I think Damian Collins did a good job with the DCMS report. These protections against electoral law failures and information war failures. But this government, who are the beneficiaries of all that, are the least likely to implement them. So I think the dots only connect up properly to this government collapse. I think you know, both, you know, I think I completely agree with Jessica, it's opportunism, there's money involved, but it's not a conspiracy, except in the Italian original meaning of the words conspirare, to breathe together. They all breathe together the atmosphere of money and opportunism, but they will fight like rats in a sack, as we're already seeing, if one rat seems to be getting more than the other rat. So I do think the dots, lots of people join up dots. I noticed since nobody's interested in Russian intervention in 2016. By the time the report finally came out earlier this year, you know, our timeline was kind of filled. It's the Russians, you know, it's not just the Russians. But, you know, Putin is a player in this. I think people, citizens have to join the dots and activate. You know, that, especially in this media world, we've all got to become citizen editors, if not citizen journalists. And your relatives, we get a copy of Byline Times, you know, tell them good sources, debate with people. And I think I am, like Jessica, optimistic that the groundswell of bad news and their venality, which will collapse under the weight of its own opportunism, and the groundswell of bad news will lead, I don't mean an uprising like the French Revolution, but a massive sudden rejection of all this. You know, the polls for Remain are still vast. It has been done. But those values which we think about, freedom of movement, the rule of law, international cooperation, we can stick by those and move closer. And I think a little bit of sudden convulsion. I mean, who would have thought that a year ago, celebrating his election victory with Dominic Cummings would be out? Well, I think I did, because I know what a nightmare he is to work with. But you know, things move really quickly. So who connects the dots? It's you. You tell your friends. You subscribe to Byline Times and crowdfund anything Jessica's doing, and pass the message.
I would just add that, I mean, it's to Sarah's point, as you say, Sarah, because we've had effectively 4 years of silence from the opposition, we have also not had proper information from the media, because we haven't had a balanced and active debate over the past 4 years about what this is really all about. And now you would expect people to know, well, they know a lot more about the EU than they knew before, but there's still a kind of gaping, huge gaps in people's knowledge. And Labour's in a total double bind because it's absolutely against no deal, quite rightly. And therefore it has no choice. It has to agree to this deal unless it abstains on the deal on the basis that it will go through anyway with enough Tory MPs. So I think Labour's in a very difficult position, but I suppose the strategy, I don't actually know what the strategy is, but I suppose the strategy might be when it's exposed to be a disaster, they will simply say it was never our deal. And whether or not we voted for it, we had no choice. That's what there was. It was always their deal. So they have to own it. But I mean, I think if there is a deal, it will go through. And I would have thought that Labour has to support it. And we'll see whether after that, Labour starts talking up about why it's not working. And I would have thought that they will do.
Well, thank you very much for that. And I think that does open up a whole Pandora's box, because we've been talking a lot about this in our group, Oxford for Europe, and whether we should be encouraging people to write to their Labour MPs where possible to say, please, please, please abstain rather than voting for this deal, because you'll mute yourselves. You'll tie your own hands by voting for it. And I'd be very interested in your views about whether that is in fact a correct interpretation. But the other question, and it's been asked by a couple of people, just for us on the ground, in conclusion, are there practical things that we could be doing right now in terms of contacting those in authority or making our voices heard that will help to change the outcome? Maybe I can just put that to you as a concluding question.
I know less about this, so I'll go first and let Jessica wrap up. I think she made a very good point about the bind. I think, you know, Boris Johnson came to power under Cummings' slogan, we assume it's Cummings' slogan, his acolytes, get Brexit done. They will always cry betrayal. They're already crying betrayal. It is a system of betrayal. No Brexit is perfect enough. Unfortunately, they have to get it done. And then that's rebuilding. I think, well, Starmer is a lawyer by training. I hope, and he managed to navigate the position, which might be divisive or ambiguous with Corbyn, but I think they would have lost much more severely without they became taken an Lexit position. I should trust him that it will, you know, the key thing is Johnson's got to own this debacle. The Conservative parties which have been taken over by UKIP Light have to be recognised as such. I never understand the tactical. People can remember if they voted for it or abstained against it. They can say, "Oh, well, you voted for this bill. Well, you're going to give us no deal." I think Jessica's got a point there. Nobody will care. It'll be known as Johnson's decision, and any tactical thing. You know, and we just got to hope it's not a no deal, because that would be catastrophic. It will be a bad deal. And we have to, I think as Remainers, I'm a staunch Remainer, we have to accept that is over. We're now returners, or, you know, the values of Remainers, I keep on saying, have to be pushed forward. And that leads to a joining down the line. And we can't go down this route of betrayal. You weren't firm enough Remainer, because that's paying into the Leave camp. You weren't a real Brexiteer. We've got to know those fundamental principles which have been lost in this last 4 years. We have to abide by and find a way of embedding them, whether it's exchange in your town, turning certain rights and responsibilities, enshrining them, you know, whatever route. We can't go back and cry betrayal from 2018 or 19.
Thank you.
So I don't think that we can do anything to influence the short-term outcome. I mean, the short-term outcome is in the next, what day are we, 24th? It's in the next few days. Really, I would have thought, I mean, they are talking about the possibility of having a sort of another transitionary deal, in the sense of signing up to something which will then be renegotiated just to avoid a no deal. but I don't think there's anything we can do about any of that now. All I suppose we can do vis-a-vis our MPs is just keep watching what's happening. And when we see things like these contracts or people who are people's husbands or wives or sisters or business partners getting public appointments, say that we'd like that to be raised. Why wasn't the post advertised? Why wasn't the contract advertised? That kind of thing. So I think at the moment, all we can do is just kind of watch and just keep an eye on things and make sure that we give the information to the MPs to raise in committee or in Parliament.
Thank you very much.
Well, thank you both so much for your time and your thoughts. It's been a fascinating discussion. I'm sure we'll all agree. It's very sobering. I take some comfort from the idea that it might, this government might collapse from the weight of its own inadequacy and emptiness, and that, you know, news from across the Atlantic helps the progressive cause. And what I'd really like to say, apart from a huge thank you to you both and for everyone for coming, is that it's so vital that we keep these conversations going in these very difficult and sobering times. I hope I speak for all of us when I say that holding these debates is galvanizing, reminds us that we're all part of a community and that we are many and we're not going away. And that journalism and the rule of and the courts are a means of exposing what is rotten at the core of our government right now. So yes, I think it's just an obligation for us to all keep going. And in Oxford for Europe, I'm so grateful for all of our colleagues for keeping on going and putting on events such as this one, which are really, you know, food for thought. And we're already organising our next meeting in a couple of weeks' time. So we're not going away anywhere. So, but yeah, to both of you, thank you both for your contributions enormously.
Thank you. It was a pleasure. Thank you very much.
And just to add on the heels of that, first of all, thank you very much, Lizzie, for chairing the meeting so well. And thank you all for coming and for your many comments. I should say we could have gone all night with all the observations we've had on the chat, and it just shows how much interest there is. I think it's, although obviously a lot of what we heard is somewhat depressing, and particularly in the short term, at the same time, I think there is hope for us. That it's good to know that there are people like Jessica and Peter, and indeed Jolyon Maugham and many others out, who are prepared to stand up for what they believe in. I think that's highly commendable, and we need to hold on to that thought. And there is hope for the future. The next meeting we're going to have, and I wanted to particularly flag this up, is with Chris Gray 2 weeks from today, and you should all receive communication about that. I hope you've all, when you registered, agreed to go on our mailing list. You can still do so via the website if you want to, and there'll be information there bringing you up to date. The other thing I was just going to mention was Byline Times. I think Lizzie mentioned it earlier. So Peter's work has been invaluable, and it is a wonderful and highly informative publication. We have a local version. There are byline publications in various parts of the country, including the West of England bylines, for which John Hill and Lizzie and I are involved, and please look out for that. I think at that I will just conclude by saying, if you want to all unmute yourselves, and then you can express your appreciation to our speakers in the usual way. Thank you.
Shall we clap? Unmute.
Thank you both.